we got R4 night.
All right.
R5 no reply.
All right.
Honorable Governor no reply. Now, let's. Of course, if I go on, then it has to be without prejudice to dealing with any rejoinder which counter which closes. That's the point. Yes. I mean, it's not my fault, but it's an odd procedure. My lord is kept the whole afternoon, etc. Two of them have not filed a reply. R5 is not, and the governor is not.
No, if you want to go on, you can.
I appear on behalf.
Yes.
Now, I am appearing on behalf of the learned Solicitor General.
On behalf of,
I will do this, Malats, that I can go on for a while, and in the light of any reply they make orally, in the meanwhile, I'll have to file a rejoinder in any case. I'm not.
That's exactly.
Because otherwise, I'll be the one prejudiced because they gave me reply yesterday night.
No, there are some.
Not yesterday.
If objections, wait, sir.
Please.
If objections are filed and which would necessitate a rejoinder, then you may as well do it. If you want to submit, submit, no problem.
No, therefore, Malus, I was really advised to do a dual procedure if it is possible. I've not done it normally. Right. I argue for a while, Malus.
Right.
But in case I have to deal with, I mean, there are so many things they've said here. So obviously, Malus, I'll have to have a right to file that in the course of, Malus, whatever the next date of hearing, etc. Because otherwise, Malus, I'd be prejudiced. And in any case, two parties have not filed anything at all.
That's the governor and
R5.
On behalf of R5, let me make the position.
R5, complainant.
Complaint, respond number 5.
All right.
But I have examined the petition copy and the annexures which have been filed along. Insofar as our the arguments are concerned, we will be relying upon the documents which they have filed along with the writ petition.
So you're not filing
there is nothing else for us.
You're not filing any
nothing else on record.
That should be recorded.
Insofar as we are concerned.
One is over.
Questions of law have been raised. And the documents have been filed along with the statement, writ petition. We will be relying
on. As far as the learned governor is concerned, if I may interject, Malad, I am appearing on behalf of the learned Solicitor General. Since a question of law has been raised, the office of the learned governor will be assisting this court on question of law. If required, my lords, we will produce the file of the honorable governor which led to the decision making. My instructions are to state that as of now, we are not going to file a reply and we'll assist the court on the questions of law raised. We'll file written submission. During the course, after hearing Dr. Singhvi's submissions.
Only delete
Our only submission is that the hearing should not be delayed, my lords. My lords
wait. Yes, sir.
Only delete the word as of now.
Please, my lords, the statement.
One line was required. I'm not filing a reply. I've noted that for both R5 and for Honorable Governor.
R5 and
caveats as of now, etc.
But in all fairness to the petitioners, they have produced practically every document possible, which led to the decision of the Honorable Governor. Therefore, Lord, we'll be relying.
I'm so happy that I've obviated.
When I said that, but I meant it. I meant it in all fairness. They have produced everything possible.
I am also taking it as a compliment that my comprehensive petition has obviated the need for counter from at least two parties.
No, I'm talking of the documents.
So I think if those two are not filing the objections, and
in the course of whatever the next date is, I'll file the rejoinder to the other two.
If you want to submit, you can submit.
Yes. So, Lordship, I record, there are no replies from these two because I don't want to be ambushed later on this.
Yes, that I will record.
It will be said later on that unrebutted allegation, this, that, etc. I don't want that. I want to be.
I will record the submissions. Yes, let me just record that. The learned senior counsel, Sri Prabhulinga Navadgi, representing the fifth respondent, would submit that they have no objections to be filed in the case at hand as the question as what revolves around the present challenge is pure question of law. He would further add that all the documents that are necessary to be relied upon is already produced by the petitioners and no further documents would be required. The learned counsel representing the Solicitor General, who represents the second respondent, would also submit that since pure question of law is involved in the case at hand, no objections need be filed, but the file relating to the grant of approval under 17A would be produced for a perusal of the court. That's your submission, right?
Please, Malad.
Yes. That's right.
Now you can, yes.
My third statement that I have received these other two.
The learned senior counsel,
Abhishek
Manu Singhvi, representing the petitioner, would submit that the objections filed by R4 and
R4, 3 and 4.
R3 and R4 have been served upon them, one of which is served 48 hours ago and the other about 24 hours ago. Therefore, he would seek, in case a rejoinder is required, he would file the same in due course. The submission is placed on record.
Would my lords also record that we will be filing written submissions on points of law?
On points of law, all right. The only second respondent ideyalla, the learned counsel would submit that written submissions with regard to the point of law would be filed in due course. Yes.
Same with me as well.
Both, yes. Yes, sir.
Now, let's on just to go point wise and to focus on the narrower issues, because ultimately.
Have you filed any synopsis, written submissions, or something? Anything?
No, I was actually, frankly, waiting for the counters, and I would have covered everything in a comprehensive thing. So I will, when I file my rejoinders, I will put in written submissions also.
Yes, sir.
But I thought I'll deal with all together, so I was waiting.
No problem. Yes.
Now, let's. Your Lordship may just consider this point by point. Your Lordship remembers I started last time with 17 capital A.
Yes.
When I came. Now, let me break up some of the interesting facets of 17A, which I submit by itself. I don't want to oversimplify. I don't want to exaggerate. Yes. By itself, this one point would be sufficient to allow the petition without oversimplifying. And it's fortified significantly by the replies we have received. The replies we have received are very interesting. I would, in fact, I don't want to sound facetious. Were it not a serious case, the replies make it quite comic and make it very interesting and make out my case completely. And on the basis of the reply, not that I'm asking Lordship to decide on the basis of reply alone. On the basis of reply alone, this petition can be allowed. Let me explain why. 17A first. Now, my first point when I opened last time, without the benefit of replies from R3 and R4, which we received yesterday, etc. The point I had made was that 17A needs prior approval. A, let me break it up point-wise. B, prior approval is mandatory under your Lordship's established several judgments. And C, the textual ingredients of 17A, leave aside anything else, even the textual ingredients of 17A were ex facie not satisfied, and yet the governor has granted sanction. Two of the textual ingredients of 17A not satisfied were only on the application of an investigating agency / policeman. That is one. There is no application by any investigating agency or policeman in the present case. And that I submit is a condition precedent of a mandatory provision of the textual language. And the second was that it must relate to a decision taken or a recommendation made by a public servant. Now, these two ingredients follow from 17A. Your Lordship saw it last time with me. Yes. No police officer shall conduct any inquiry open with police officer or inquiry or investigation into any alleged offence alleged to have been committed, where the alleged offence is relatable to any recommendation made or decision taken by such public servant. So opening is police officer or investigating agency, and recommendation made or decision taken is the second ingredient. Both are not only admittedly not satisfied, not invoked, cannot be satisfied, cannot be invoked. They don't arise. And the public servant here has neither made any decision nor any recommendation in any capacity as CM or Deputy CM, etc. This is my first point. Right. Your Lordship would see my law index alone. I'm surprised, all the cases, this is worse than carrying coal to Dhanbad. All the 3 judgments I've got, I did not realize it till I saw them. Yes. I believe authored by your Lordships. So I'm not going to actually carry coal to Dhanbad. But your Lordship see the law index. There are 3 judgments cited by me in the opening. Yes. The first proposition is Ashok versus Lokayukt. Second is Yashwant Sinha versus, not that. That's
Supreme Court.
That's the third one, Shirupa. And most important, fourth one, Praveen Kumar.
Fourth one was the first one. Rendered.
That's right. That's right. Yes. This put wrong in the serial. Now, these make it clear that this is mandatory, this is clearly necessary, and that it has these ingredients. The relevant para of this Praveen Kumar is para 14 to 16.
That is with regard to application of mind.
Mind.
Yes.
And it said 138 balls. Woodbine boss want to read it because I don't think it's necessary. The Lordship has seen that it's.
Yes.
These are not balls altered, appealed, challenged in terms of variation. I don't know if the challenge or not.
These judgments have become final.
Final. I mean, but certainly not varied in any manner. I don't know if they're lying in some challenge here or there, but they're not varied in any manner. The Srirupa is para 23 to 28.
Yes.
And that starts in my compilation at 106.
Yes.
And the third one is Ashok, para 15, which starts at page 5 of the compilation. So first point, bullets, the language history. Second point, the 3 cases. And 2 additional points before I come to what has happened now, which is very, very interesting, virtually almost comic. The circular at 260 of the paper book, which is the circular of the Honorable High Court of Karnataka at 260.
That is implementing Ashok.
So that your Lordship has noted. And then, Malaz, there is a SOP, a procedure
of the Government of India.
Of the Government of India, dated 3/9/21 at page 703.
Yes.
Which my Lord saw with me last time, para 2 and 3.
Yes.
These are the 5 points I made in the opening, QA 17A. Now, there is something interesting, a lot of interesting developments on 17A alone. We stick to 17A for the time being. And your Lordship will note those developments. Well, it's one of the, I would say, the principal complainant, if I may give him that special post and position. I mean, even amongst complainants, there should be a hierarchy. The principal complainant has now filed a reply saying that
which respondent are you
R3.
Who appears for R3? Aniva. Yes. R3.
Reply, which I'll be presently reading in a minute, says variously, there is itself is a bit of a fudge, but and I'll take it both ways. He says no 17A is required. And then he adds 1 or 2 places, just a word. He says unconditionally no 17A is required. I'll read that verse in a minute. And then he says not required at this stage. So he takes both, please.
Objections. List of citations.
I will take it either way. Objections of R3.
Yes, it's here. Yes, sir.
If your Lordship will turn to that verse in particular at page 60 and 61, and I'll take the liberty of reading this a little slowly. Para 20 at 60.
Yes, sir.
In the private complaint filed before the special court, the stage of court taking cognizance has not yet reached. And R3 in his private complaint has only sought for reference to the concerned investigation officer for investigation under 156(3) of the CRPC in accordance with law. Therefore, the question of taking cognizance at the current juncture does not arise before the special court. It is submitted that on this ground also, R3 need not obtain sanctioned as envisaged and 218. Currently, the private complaint, which is an unnumbered one, is posted for hearing before the special court. Nevertheless, the R3 applied for sanction. Mark this word. Nevertheless, R3 applied for sanction to the governor in adherence and compliance of the honorable judgment in Ashok, as the same is currently the law of the land, as an adherence exercise and a procedural formality, not any substantive requirement, a procedural formality, pursuant to the circular issued on 4th of July. Now read the next 4 lines.
Yes.
Although the order of sanction from the competent authority under 17A is not required for the instant case, and the sanction under 218 is not mandated at this juncture. Now, Milits, I have 3 or 4 points here. And I don't want to sound facetious. The whole of writ should be allowed, or he should withdraw his complaint, rendering the sanction complete waste of time, and the governor should first impose costs on him. And then later on, your lordship should impose costs on him. Your lordship, why? I'm not making a facetious comment. Now, this person, your lordship, read his pleading. It's on solemn affidavit filed in the court, given to us yesterday, day before. That's why I said, were it not serious for me, it would be comic. This person, Malaz, like Alice in Wonderland, applies to the Lokayukt. The same person. Please turn to Malaz. I'm sorry, Malaz, to the governor.
Yes.
At page 48.
Page 48. Was it applied before the Lokayukt also?
Also
Not
the Lokayukt.
Complaints with Priyanka Srivatsal's case.
I'll do that
Complaint
also.
was lodged.
First, come to the governor.
Complaint was
lodged.
Apparently, Malaz, the entire machinery must waste time on his vexatious complaints, which he says, I don't need to make a complaint application. Why should I trouble the Honorable Lokayukt and Honorable Governor? Come to Malaz, page 43 first. Sorry, 48 first.
Of the objections?
Of the Malaz, of the petition, of the paper book. Volume?
Yes.
Now, your lordship just read his affidavit. Now read this. His Excellency, the Honorable Governor, on 26th of July 2004, first line, request for sanction for prosecution of Mr. Siddaramaiah, etc., etc. And read the fourth line, under 17A and 19. And 218 also, Malaz.
Yes.
Also, Malaz, end this at 69.
Yes.
Which is the last para. Wherefore, it is requested from your good office to directly grant sanction for the prosecution of Siddaramaiah.
Yes. What is this? Illegally gaining rupees 55 crores, is it?
Where is it written?
No, the complaint is about that.
Please.
55 crores.
Yes.
For sanction.
He makes a quantification of this whole issue and says this is illegal. At the moment, we are on his affidavit and we are on this. Right, Malaz? Now, again, this is not just a single Malaz swallow in the summer, not a single bout of madness. It is a consistency. Page 200. Same volume. This is Honorable Lokayukt.
This is to the Lokayukt. This is 154.1 complaint.
Please.
Yes.
Information of so-and-so, so-and-so. Where is it? Why did you give me Lokayukt? Does it have?
Yes.
Does it mention sanctions? You have to give me only when it's sanctioned. Now, whereas here he has made a complaint where he does not say anything about 17A. Is it there? Oh.
No, this is only a complaint.
Correct.
It need not comply with 17A in this.
Right. No, I'm just saying, Wallace, he's come all this way to the governor, etc. He makes no mention about anything.
Yes.
Now,
this is earlier to the governor's.
That's right. That's right. Now, Wallace, put it like this. He has made a complaint. He seeks sanction. Governor grants sanction. It's not a suo motu governor action. The governor action is based on on XYZ's complaint. That complainant says not necessary. Well, then, Malaz, obviously, since he will not withdraw it, your lordship should, Malaz, treat that application for sanction as non-existent on this basis alone, on the counter affidavit. And therefore, the basis and the foundation of sanction goes. We are not here to answer academic questions. We are not here to, Malaz, the entire foundation of the sanction order goes. And this is not, Malaz, this is Malaz, a person who is facing this like me, the petitioner, has every right to say this is absolutely a farce. I didn't mean it lightly when I said the governor should, before sanctioning prosecution against me, impose costs against him. If he has the power, certainly your lordship has the power. I don't know if the governor has power to impose costs, Malaz. So this is the short point on which the on the second aspect of 17A, and it's a full point, Balaz, I submit with respect, that this cannot be just that you come to system, you set a whole thing in motion, and then you say not required at all. Balaz, then you have to be straight in your stand. You take your chances. What is the problem? You go ahead, prosecute, we'll see whether sanction is required or not. You can't have it both ways. You get a sanction, when I come to court, you tell the court in the counter affidavit, I didn't require a sanction.
Don't you mean to say that they can proceed with it without sanction?
They should. They should, Balaz. They should have the courage of their convictions. I'm not saying anything. I'm only defending. Imagine, Balaz, that's why we say, Balaz, that's why. No, there's another facet to it. In practical, not in law also, Balaz. People like the governor should be restrained. That's what happens when anybody walking about the path makes an application. Well, should not the governor have said that you don't require sanction? If you applied your mind. I'm not saying he would have or should have. But if anybody on the road comes to him and says, give me sanction, he's so eager to give the sanction, the man himself says, no, I don't need sanction.
No, but approval under 17A is not sought prior to all actions. It is when the court proceedings were on, I guess, after the complaint being before the court.
Yes.
The approval is sought at the hands of the governor, not before that.
No, it's
when
not
was the complaint registered?
First, the sanction was sought.
Amal complaint registered.
Right at the threshold. And your lordship, 3 mandatory judgments are prior sanction. So, Balaz, this is Balaz very serious. He's playing ducks and drakes, A, with the governor, who has actually granted his prayer, and B, with the court. And Balaz, the only legal consequence of this is, of course, I'm not saying that he's going to withdraw. Should be his withdrawal on the basis of his affidavit. He can't, Balaz, the affidavit prevails. Perjury prevails on an affidavit. He can't be perjuring himself by filing the affidavit before your lordships. So on that affidavit, he must withdraw. Otherwise, your lordship should, Balaz, treat that as non-est. The moment it becomes non-est, the sanction goes. So that's the ground for the sanction to go. It's not a suo motu sanction.
No, it's not.
Now, Balaz. Now, the other person, like Alice in Wonderland, gets curiouser and curiouser. That is a phrase used, Balaz, in that book. It's quite remarkable what happens in the other case. That is Mr. 4, R4. Well, he has got sanction also from the governor. Your lordship has got an order. The final order mentions, suddenly, notice came to me only for R3. That's why I mentioned this.
A particular paragraph mentions these two as well.
These two also. So the governor is purportedly applying might to 4 and 5 also. But it now transpires that R4 never sought sanction. The other fellow says, I need not have sought sanction, but I did. I hope I'm clear. If you actually examine R4's complaint, which has now come to me, and I'm going to ask my learned friends better equipped in Kannadiga to read it to all.
Maybe some restraint, my lord, on
wait,
usage of words.
When sin is submitted, wait.
I'm going to ask you to read it.
Anything I'll ask you.
On usage of words, my lord. There may be some restraint.
About what?
Some fellow, Alice in the Wonderland.
Yes.
My lord, it's not, my lord, there's no impediment for me to use such words.
Yes.
But protecting the sanctity of this honorable court is utmost important.
If the literature of Alice in Wonderland standards
court,
are objectionable, unparliamentary words, I plead guilty, Willis. I plead guilty.
You may address them as respondents, that's all. Yes.
Now, Willis, we are in a case where the first person says that I applied for sanction, but I need not have applied, which is sufficient to allow the sanction to fall.
All right.
The second person says, I never applied for sanction. Then how did the governor grant on what?
He has not applied. That is a fact.
That's fact. Now, we'll just see that. Just see that at 376, his application. It's quite remarkable. 5th of July, 2020.
Whose application?
R4's. To the governor, which is now, well, we have got only with this reply.
76 of what?
376 of R4's objection.
R4 objections, madam. R4 objections. Yeah.
Now, Milits, I made them read it to me slowly, and I was happy to note that I could understand most of the slow reading of Kannadiga. But I can't read it to your lordship, so my learned friend Mr. Ravi may kindly do the honor of reading.
This is the Snehamayi Krishna. R4, is it?
R4. The last, just a relevant portion.